Good morning. Thank you for joining us today for the OIA Outdoor University and Stoel Rives webinar, With Great Power Comes Great Responsibility, Tips for Minimizing Risk in E-Commerce Transactions. This is the fourth in the series, the Law of Outdoor Industries webinars, which we will be presenting throughout 2013. Today's webinar will be presented by Catherine Parrish-Lake and David Pacheco. Catherine is a partner at Stoel Rives, specializing in intellectual property licensing and trademark and copyright prosecution. David is an associate with Stoel Rives Technology and Intellectual Property Group. Both Catherine and David practice in the firm's Salt Lake City, Utah office. Currently, all of the attendees' telephones are muted to cut down on background noise. We welcome questions using the chat feature, and each presenter will get the questions in real time. If your question is not answered right away, it will be addressed at the appropriate point in the presentation or at the end during a general Q&A session. Your questions are welcome, so please use the chat feature freely. With that, I turn the time over to Catherine and David.
Okay, well, good morning, everyone. We're excited to have this opportunity to talk to you this morning. We're particularly excited about the subject matter and our involvement with the Outdoor Industries Association. I know, at least for me, is I enjoy being able to work in the industry and be involved with clients in the outdoors industry arena. It reminds me a little bit of one of my favorite New Yorker cartoons, which, because of attorneys like us, I'll have to describe to you rather than show, at the risk of not having a license for it. But anyway, this cartoon shows a little boy talking to his dad. The little boy is dressed up like a cowboy, talking to his dad, saying, "If I can't be a cowboy, I'll be a lawyer for cowboys." And so I sort of feel in ways, if I can't be a professional snowboarder or can't make ends meet working at a ski resort, maybe I can be a lawyer in the industry. And so anyway, this morning, as Melanie introduced it, we are going to be talking about e-commerce and how to minimize the risk in e-commerce transactions. And so this slide here shows some numbers. I probably don't need to convince anyone of the importance of e-commerce. But I will point out that as we're talking about it this morning, e-commerce, we mean more than just online retail sales. We're talking about online marketing, in particular social media marketing and advertising, which, while according to these numbers, retail sales as a whole in the U.S. may make up only 5% of total sales. Certainly, the broader definition of e-commerce as we're using it has a much greater impact on total revenue through marketing efforts. And so some of the risks, or some of the difficulties presented in dealing with e-commerce regulations certainly aren't unique to e-commerce. It's a problem we probably see across the board with regulated industries and regulated aspects of commerce. And that is, as we're keenly aware, legislation is generally cumbersome and slow. And the regulatory process lags behind sort of real-world innovation and real-world tactics, and so often we're left trying to apply old rules and old regulatory schemes to sort of the new practices that were never contemplated by the rule makers before. Or when we do get a new rule, often they're untested. We don't have much experience to go on, much prior case law to go on, and oftentimes they'll miss the mark to some degree, and then we're left trying to work around that. And so our goal this morning is to provide some practical tips based on recent developments, and to do so we looked at 4 broad categories of e-commerce and some recent developments in each of these categories. In particular, we looked at generating traffic, interacting with consumers online, using existing third-party tools, and using mobile devices. And so with that, I will jump right into the section on generating traffic. And what we mean here is, tactics, methods, doing whatever we can to get the consumer to our website or our retail store online or brick and mortar. And so, in particular, I'd like to talk about 4 tactics and some of the potential risks with these tactics. So, we're looking at search engine marketing, or SEM, and that's things like keyword advertising, in particular the Google AdWords platform, search engine optimization, comparative advertising, social media marketing. And the risks we'd like to highlight are sort of related, all 3 of them, but it's risk of trademark infringement, risk of violating unfair competition laws, and the risk of liability under false advertising laws. And so the key consideration for all of these, and sort of the guiding principle throughout this section, is consumer perception. We want to ask ourselves, what does the consumer see when he or she looks at these ads? And that's sort of the guiding principle for whether or not there's a risk there, is depending on whether the consumer's perception is misguided or not. So the first tactic I'll point out briefly, and the risk associated there, is using a third party's trademark in SEM and SEO efforts. So in particular, using your competitor's trademark, or your competitor using your trademark, to try and generate traffic through sponsored ads on search engines. Meaning, when a consumer types in your trademark or your product, their link comes up. And so there has been sort of a long history of litigation about this matter, but I think we've, especially with some recent developments, sort of came to a general rule that the practice is acceptable as long as there's no likelihood of confusion. And courts are reluctant and rarely find that there's likelihood of confusion in these cases. And it's for a number of reasons. It's either because the trademark doesn't appear on the ad, and so consumers, don't believe that the ad is associated with the alleged infringed trademark owner, or simply, the courts will point out that consumers are sophisticated and no one's fooled by these sponsored ads. So when I go in and run a Google search for something and I see a sponsored ad, I'm savvy enough to know that that's not an organic search result, that has come up as a result that's an advertising effort, and that this company is trying to get me to click on that link. And I'm not necessarily going to believe that the link comes from the company or the product that I'm searching for. And so I point out two cases here in particular that are fairly recent and give a little bit of direction. The first is the 1-800 contacts versus Lens.com, which is a case in the 10th Circuit, which is sort of here in the Intermountain, the court covering Utah and Wyoming and some of the Intermountain states here. But it's been noted sort of across the country by courts and commenters alike. This is an ongoing dispute between the two, where Lens.com purchased the keyword through Google's AdWord program for 1-800 contacts. And so anytime someone searched for 1-800 contacts, the Lens.com sponsored ad would come up. But for the most part in these ads, the actual trademark, the 1-800 contacts trademark, didn't appear. And so in a decision from just a few months ago, the court said that in these cases where the trademark never appeared in the sponsored ad, there was no likelihood of confusion. Even though Lens.com had purchased the actual trademark and was using that trademark in commerce, the court found, the consumers were never going to see it and weren't going to be confused. And then in another case from a Colorado District Court from last year, the General Steel Domestic Sales v. Chumley case, there the defendant was actually using the trademark on the sponsored ad. So unlike the 1-800 contacts case, the plaintiff's trademark did appear on the advertisement, and the court found that even so, consumers were still unlikely to be confused because the consumers were savvy enough, and the context of the ad didn't suggest that the plaintiff was at all affiliated or sponsoring that ad. All right, so the next tactic to discuss is comparative advertisements. And that is, of course, when one company advertises its products by comparing itself to another company or that company's products. And so a pretty good example that we're probably all aware of in the industry and that's going on is the Gore-Tex versus the world, as I call it here, which I think was highlighted pretty well in an April 2012 article in Outside Magazine. It sort of discussed Gore-Tex's market share and competition with Gore in the performance fabric area. And there's a whole host of examples of advertisements that, to a certain degree or another, directly compare the product with Gore-Tex. I'll provide one example here. This is Neo Shell by Polartec. This is one of their ads, which certainly is a subtle but I think easily understood reference to Gore-Tex. And so the question with comparative advertisement, like with keyword advertising, is consumer perception. And so as we look at these comparative advertisements, the question is whether consumers are going to in any way be misled or confused by the advertisement. So in most cases, the answer is no. The consumer is not going to believe. So going back, I'll go back a slide to this. Consumers that are savvy enough to understand that this is directed at Gore-Tex are not going to believe that Gore-Tex is in any way affiliated with Neo Shell or sponsored this ad or going to be confused about the source. So in addition to the question about confusion, the other question is whether the ad is deceptive or misleading. Does it misrepresent either your product, your company, or the competitor's product or company? And if that's the case, there's a number of ways you can be found liable, a number of risks that come from that. So the FTC has power to enforce advertising laws. It can bring their own action against a company for false advertising. Consumers can bring an action for false advertising. Competitors surely can if they feel that the advertisement is false. Even if it's not false, even if there's nothing misleading about the competitor in the advertisement, if there's something misleading about your product, if there's unsubstantiated claims or something that maybe don't hold up, it could be an invitation for a competitor or anyone who's possibly harmed by the advertisement to bring the action. So finally, I'll finish off this section with a couple practical tips, which is just sort of reiterating what we've already talked about, which is to consider the advertisement from a consumer perspective. So try and put on your consumer lenses when reviewing an ad or reviewing a traffic generation tactic, and ask whether there's any possibility or likelihood the consumer is going to misunderstand the ad, be confused about who's sponsoring the ad or where the ad's coming from, or whether the ad makes claims about your product or another's product that may not be true. And then the final tip here is to consider your target competitors and common market practices, which can be a barometer for risk and be indicative of sort of where, what's reasonable, at least in the industry, as far as comparative ads and claims and what consumers are likely to believe. And so with that, I will turn it over to Catherine.
Thanks, Dave. So the next item that we're going to talk about is online interaction with consumers and how I think all are aware of the tremendous opportunities and creative new methods of interacting with your consumers, obtaining information about your consumers, customizing your communications with your consumers that are brought about by the technological advances, both online, and we'll get to mobile in a few minutes. But we wanted to discuss some of the risks that can be presented in taking advantage of those new marketing opportunities. And in looking at the interaction with consumers, it really breaks down into two key areas. I think a primary conduit for many businesses is still the interaction that comes through the website, and that's what this next section is going to focus on. And then Dave will talk about how the interaction can be affected by a third-party site or a third-party tool that you may be using. So when you're going out and taking advantage of Facebook or Instagram or some of the other third-party tools that are available. With regard to a business's own website, the rules of the road for the interaction with consumers really are generally provided in two documents, the terms of service and the privacy policy. And these are typically posted to a website through links sometimes, and we'll talk about why you should perhaps be thinking about doing this more. Sometimes they are presented as click-through agreements. And these are, as attorneys, we draft these things. We're probably some of the few people or a few category of people who actually pay much attention to them, at least until there's a problem. And a recent case involving Zappos kind of highlights some of the issues that can come up and why these documents are important for your company and as you're developing products and new online techniques and using new tools. In Zappos, in 2012, they had a hacker that broke in, and as a result, there was a data breach that involved around 24 million Zappos customers. So as you can imagine, this created a lot of interest suddenly in the terms of service and in the privacy policy. And many, many plaintiffs' attorneys took advantage of the situation and filed lawsuits. Zappos, unfortunately, was not able to look to its terms of service as a binding contract because the court found that it was ineffective at binding the customers to the terms that were provided there. Excuse me. And the court found that for a couple of reasons. First of all, Zappos had included a provision in the terms of service that allowed it to unilaterally, so by itself, change the terms of service whenever it wanted, update the terms of service, and then customers that came onto the site after that would be bound by whatever the new terms were. The second reason was the court found that most consumers just did not know that the terms of service actually bound them or existed. Zappos was using a very common technique, which is called a browse wrap agreement. This is an agreement that exists on the site and is found through a link. The court found that Zappos' link was buried among many, many links on its site. There was nothing conspicuous about it, and there was nothing that Zappos did that drove consumers to find it. And because of those reasons, the court basically said that it's not a contract, so you're just left to the common law rules that would govern interaction. And that prevented Zappos from being able to do things like move the cases to an arbitration environment out of a court environment. So there's a couple of practical things that companies should be thinking about doing with their terms of service and their privacy policy. One is, as I mentioned before, consider making it a click-through agreement. If you have a registration process, if customers are purchasing goods on the site, it may be somewhat seamless. I understand it's an additional click, but you may be able to incorporate it within those parameters fairly easily, and that will make it more likely to be enforced against the consumers. With regard to the unilateral changes, that can be a bigger hurdle, I think, for some companies to overcome, but you should be looking at whether you can live with having customers bound by whatever agreement they've clicked through to accept, or even whatever agreement existed on the day of the contract, or if you can implement some sort of amendment policy that will, be effective at having them re-accept terms if there are changes that are put into place. So that describes sort of the terms of service as they interact with the customers. It is important to understand that that's only one of the roles that terms of service play. The other is to establish the rules of the road between your company and other companies that may be using the site. And these may be companies you don't particularly want to use your site, that are using robots to go in and scrape your site, or that are doing other things that are not intended. And the prohibitions in terms of service have been found to be binding on other companies. The factor that I think kind of persuades courts in this situation is when they find out that the other company also has the terms of service on its site, it's then very difficult for that company to say, we didn't know about the terms that were posted to the other site. The same really is true for privacy policies. The Children's Online Privacy Protection Act is something that's been around for several years now, but it is worthwhile as your company grows, as it expands its products, to go back and revisit these policies the same way you do the terms of service. Think about how consumers interact with them. What do they see? Some organizations, sorry, we're a little behind on the slides. Some websites are going to a privacy label that is similar to a nutrition label to simplify the privacy policies even from what is included in writing. And with online technology, the advertising environment has become much enhanced. Again, with those enhancements comes great rewards, and as the title indicates, there's also new responsibilities that crop up. The overriding thing to understand, which Dave had mentioned earlier with advertising, is all of the rules that apply to traditional advertising also apply online. So an ad needs to be truthful, it needs to not be misleading, you have to have adequate substantiation for the ad. Product reviews are one area that is growing online and is becoming of growing concern to both the FTC and to some of the third-party sites that, you know, really make their business out of having product reviews, active product review sites. And I think most people would understand that if you were to run an ad in Outside Magazine and you had this glowing review of a new product that appeared to be anonymous or appeared to be from kind of an average user of the product, but was actually drafted or actually comes from your marketing director, that is probably going to not be acceptable and you may have liability from that. The same is also true if it's a product review that appears on a web page under where the product is offered for sale and it appears to come from someone who's purchased it, who's reviewing it without having any links to the company. The same can be true of bloggers. If you're providing influential bloggers, or any blogger for that matter, with incentive to review your products favorably, then the blogger needs to disclose those. If you're linking to the site, then it's also possible that the company may have some liability if it doesn't adequately disclose whatever the relationship is. And user-generated content, I think, is another tool that has become enhanced through technology. This is the situation where a business goes out and talks to its customers in one fashion or another and asks them to come up with its advertising. Talk about the way that this new snowboard product has really enhanced your experience. There's a lot of different ways of using this. New parents who are talking about the joys of their backpack and being able to put their child in it and how much easier it is to stand up with it than perhaps a competitor's product. So these are really terrific, can be very terrific marketing pieces. They have this sense of authenticity that sometimes is missing when an ad is coming directly from a particular business. They can bring certain challenges for the business. And unlike traditional media, in this area, businesses are provided with some enhanced protections that are particular just to online advertising. The two that we're noting here are the two that are most generally used. The first is the Digital Millennium Copyright Act, or the DMCA. and which covers copyright infringement issues. And the second is the Communications Decency Act, or the CDA, which covers defamation issues. And very generally speaking, what both of these laws do is they protect an online service provider, someone who's just hosting content, from liability that occurs in content that a third party has created and posted to the business's site. Where this seems to come up a lot is in when a business creates a contest. So you have the Subway Quiznos case is kind of a good example of highlighting this. Quiznos had a contest for consumers to come in and create their own ads as to why Quiznos sandwiches were better than Subway's, and they provided them with several examples of what the ads could maybe look like. They gave them a lot of parameters, and there wasn't any final decision in this case, but the judge that was considering it at an early-ish stage did find that Quiznos' level of involvement with the ads and the parameters that they were giving could be sufficient to take the protections away. And so it's possible if you are too involved, if you're giving too much information, too much guidance to your customers when they're creating these ads, that can, pose some liability, and you may not have protection that you otherwise would. Another thing under the DMCA to be on the lookout for is if you have actual knowledge. So even if it is completely third-party content that's created and you have, for instance, a chat room or a section of your site or your Facebook page where people can post different things, and somebody puts up this really great video and it uses Lady Gaga's latest hit in it, even if you didn't give them any parameters, but you somehow know about it, executives within the company, really anyone within the company becomes aware that it's on there, and it's pretty obvious that whoever it was probably didn't have the necessary licenses to use that song. Then you can't put your head in the sand. If you do that, you're not going to have the protections that you otherwise would. So some practical tips, just to summarize things, are to carefully craft your terms of service and your privacy policy for your website, and then to pull them out periodically and look at them, think about changes that have happened to your business and to the site, to the technology that you're using, and make sure that those are reflected. And then also to adhere to the basic advertising rules and to be aware of the protections that you have, but make sure that you are working within the scope of those so that they're there when you need them to be. And with that, I will hand it back off to Dave to talk about using third-party tools.
Okay, thank you, Catherine. Now I think this section is sort of builds on what Catherine has just talked about, and is perhaps in many ways a subset of what she talked about. But I think we can probably all agree is of increasing importance. And of course, what I'm talking about here in using third-party tools is primarily social networking. So, using Twitter, Facebook, Instagram, YouTube, whatever it is to interact with the consumers and to market to consumers, which, as I'm sure you all know, it has become a very powerful tool for marketing. It's relatively cheap. And the ability to target, the exact audience and drill down as almost as detailed as you want to be with your market definitions and your directed advertisements, and allows you to run concurrent advertisements and marketing campaigns to different target audiences much more effectively than we ever could in the past. And with this next slide, again, I'm probably, preaching to the choir, and don't need to convince anyone of sort of the efficiency of using the existing third-party tools rather than creating your own platform. Just quickly, here's a couple of statistics that I thought were interesting that you're probably all aware of. But as far as 72% of online adults in the U.S. use social media, just a much larger percentage than maybe I would have guessed before looking at the numbers. Facebook has passed 1 billion, and in fact, there are 1.1 billion active users worldwide, and that's just active users. That's not number of accounts. 20% Twitter is used by 69% of business-to-consumer marketers. YouTube's the #2 search engine, so people are using YouTube to locate things. And 60% of LinkedIn users have clicked on and out on the site. And so I think clearly social media, the existing platforms, are powerful and efficient ways to communicate with consumers and to market your products. But you know, at the risk of painting a rosy picture here, I want to put my lawyer hat back on and rain on parades, which is what I think we're supposed to be good at, and talk about some of the risks of using these third-party tools as effective as they are. And sort of the first tip, and maybe one of the underlying topics throughout the section, is to treat the relationships with these third-party tools, with social media providers, the same as you would with any other real-world service provider, which is to say, you know, no one's going to jump in with a service provider without looking at the terms, looking at the entire relationship and evaluating the risk. But there is that risk with social media, in part because it's so easy, in part because it seems like the social media provider is really a background provider. But for reasons which I'll discuss going forward, it's important to evaluate and understand the additional risks, and in particular to understand the treatment of your rights and the ownership of the rights, and the ownership and treatment of the things you post on these social media sites. And of particular importance, and this is touching a little bit on what Catherine already talked about the terms of service, is to review and understand these terms of service that apply to each social media provider. Now, you know, with most of these, I think a lot of them seem to have the same problem that Zappos may have had, and maybe they're not enforceable, but let's just assume that they are enforceable, these terms of service. And so I highlighted a few of them to talk about maybe some of these risks that aren't always understood by people who post on these social media sites, and of course, this is a much savvier audience than most, so you may have already considered this, but I'll point it out anyway. So here is an excerpt from Pinterest Terms of Service. It basically states that you grant Pinterest and its users, so those using Pinterest, which is interesting, and you don't see in all, you see in many of these social media terms of services, but not all, that the license goes to both the social media provider and to its users. So it grants a fairly broad license to anything you post on Pinterest. Now, while it's limited to use on Pinterest and for the purpose of operating, developing, and providing the Pinterest products, nevertheless, you know, this license would allow Pinterest and its users to maybe the most concerning aspect is to modify and create these derivative works. So take what you posted and, you know, modify it in some way, make, you know, maybe it's a parody ad, maybe it's some sort of modification, and then repost it, which, you know, in most circumstances, you probably don't want it to happen. Of course, it depends on the advertisement, but I would probably guess that normally no one's going to agree to let Pinterest use whatever they post for their own advertising purposes, you know, in many circumstances. And so I've got a few more excerpts here, and you know, maybe it's not worth going through them in a terrible amount of detail. But to quickly summarize, here's YouTube's terms of service, which basically grants YouTube a broad license to use the content that the users post with its business. And there's not really any limitation there like we saw with Pinterest. So YouTube can, say you post a video on YouTube, YouTube can use that video however they want, including by preparing derivative works, by modifying the video, taking excerpts of the video, and using that in connection with their service and with their business, which can be interpreted pretty broadly. And so in many ways it is a fairly broad and royalty-free license you're granting to YouTube. Now, it also grants a license to each user of the service, to your fellow YouTube users, and while I believe it's meant to simply, prevent someone from posting on YouTube and then going after fellow YouTube users, other YouTube users for copyright infringement for viewing the videos, by granting them a license to use, reproduce, distribute, display, and perform the content through the YouTube services. Nevertheless, it's fairly broad, and again, could arguably be granting a license for users to do things that you maybe otherwise wouldn't allow or would take steps to prevent. So the Instagram terms of service, and these are interesting, in part because of the sort of the public uproar when Instagram changed the terms of service about a year ago, and the resulting class action lawsuit. And so, as you may recall, Instagram changed its terms of service, and it was sort of misreported through the media that Instagram was now, taking your rights to your whatever you post on Instagram, which wasn't true. Instead they changed their license to read like the other license we read here, which grants Pinterest sort of a pretty broad license to use the material posted on Instagram. And so this is interesting, that Instagram sort of directly addresses that in terms of service here, by saying that Instagram does not claim ownership of any content you post on or through the service. But it is interesting that you are granting a fairly broad license to Instagram to use whatever you post through the service. And so these are, I think, important aspects to remember as you're using these different social media tools to maybe understand, the extent, the license that you may be granting to both the social media provider and to the other users of the site, and how that may affect your ability to enforce your rights or go after someone who's using your content in a way that maybe you don't approve of. That being said, it's perhaps rarely an issue. Any truly disruptive uses of your content probably fall outside of these terms of service, but it is a wrinkle to consider, and a possible defense that might come up if you were to try to enforce your claims or enforce your rights against someone using your content. So with this next slide, again, I'll go back and reiterate what Catherine talked about in the last section, that the rules still apply online. There's nothing, there's no safe harbor, there's no relaxed standards in the online world, and especially in the social media world. It may seem so sometimes, given sort of the ease and the quickness with which you can use these sites to interact with consumers and to post ads and to market, that maybe it seems like all the scrutiny and processes that go into sort of the traditional advertising and communication avenues aren't as important here. But I think I can assure you that the FTC, consumers, and your competitors are going to hold you accountable for whatever you say on social media, and it's going to be difficult to get a pass, a defense based on simply it being social media. And also another maybe cautionary point here is to remember that the content is widespread and permanent. So I've got a few examples here of Twitter posts that you may or may not have seen, that maybe give a pretty good example of some of the problems involved with and some of the risks involved with using social media, and in this case Twitter, to communicate with consumers. So the first one here is a tweet from Chrysler Autos, which as the facts turned out, it looks like the employee who posted that thought that he was signed into his own personal account and wrote this and posted this tweet, but was instead still logged into the Chrysler account. I think this ad was only online for just a few short moments, but I think, as we're probably all aware, once you post it, it's permanent. It's probably going to last forever. Someone's going to take a screenshot. Someone's going to save it. There's going to be records, cached records, electronic records, and it's not going to go away simply by removing it or deleting it. So that below that is a tweet from BP Global PR is the Twitter handle that was posted sort of shortly after the Gulf of Mexico oil spill first occurred. Now it turns out that this Twitter handle isn't the official BP Twitter handle. This is an imposter account. But I think it's important to note that that can certainly happen, and there's different ways to address that. And sometimes these imposter accounts or these parody accounts, there's not a whole lot you can do that maybe the other user is protected by fair use rules or something else. Maybe it's clear that it's an imposter account or a parody account, and there's no likelihood that consumers are going to be confused, sort of going back to the first section. But it's important to be aware of that and to maybe come up with a strategy for how to deal with imposter accounts, deal with parody accounts, whether you attempt to go after them directly, or you attempt to get it removed through Twitter or through the service provider, or simply the other option, of course, simply ignore it or start your own campaign and educate consumers that this is, of course, a parody account and you have nothing to do with it. Okay, moving on to the other examples here, we've got this tweet from Dr. Bob Parsons, he's the CEO of GoDaddy, which caused quite a bit of uproar when he posted it. A video of him hunting elephants in Zimbabwe. I put that there maybe of an example of to be aware of implications or connotations, consumer perceptions that may arise based on key personnel posting on their private accounts, or maybe to consider if that's regulated or if there's a policy there. And then finally, here's a tweet by Kenneth Cole that attempts to turn the Cairo uprising into a marketing tactic, which did not go over well at all, as you can probably imagine. Now this is, for me, sort of an important point about context. Maybe this tweet wouldn't have caused such a problem if it came from maybe a witty blogger or someone else, but there's certainly differing standards based on who's posting what. Conan might be able to tweet something that a well-respected company may not be able to, and that's probably something we're all aware of. But maybe the points here with this is to control access to the social media accounts, to implement a posting policy and approval process, limit who has access to this, what does the person posting have to do before he or she can post something? Does it, who reviews it? Is there a committee? Is there guidelines or standards for what can be posted? And then, again, I think I already mentioned it, but control access. It's maybe there's only one or two key people in the company who have access to the login information and can actually post on behalf of the company. Now, this, of course, is a balancing act, because one of the benefits of, in particular, Twitter, which we've been discussing, is the ability to sort of quickly react to to consumers posting something about the company or something relevant to the company online, and it is, you know, one of the great benefits and one of the key uses of Twitter is to be responsive and sort of monitor that and be able to get back to these people quickly and build a conversation and get some awareness and some momentum going there. And so, you know, policy, of course, you don't want it to be too cumbersome and too slow. You know, some committee that takes, you know, weeks or even days to approve an advertisement are really going to limit the possibilities and potential of using some of these social media avenues. But nevertheless, it's important to regulate this content, regulate access to this content, and make sure that you know, your Twitter feed doesn't appear in the next iteration of this presentation. Okay, so to wrap it up with some practical tips, going back to what I said at the beginning, is to treat the social media the same as you would when you engage a service provider in the real world. So carefully take a look at the contracts and how it affects your rights and how it fits into your strategy and goals. And part of that, I think, is reviewing and understanding the terms of service. In particular, know what you're getting into, know what rights you're granting, and how it may affect your rights in the future. And then finally, we just talked about to control the communication, to make sure that your social media advertising efforts are subject to the same scrutiny and same standards that other advertising and marketing efforts have to comply with. And so with that, I'll turn it back to Catherine.
So now we're going to talk about mobile devices, and I think the key thing to start with here is to remember that the screens are smaller, but all of the same rules, again, apply. So we've taken the rules that govern traditional marketing and applied those to the online context, to social media, to some of the new developments that have happened there. The same is true. You take that same set of laws and you apply them to mobile devices and the use of mobile devices. Some of those unique laws that do provide safe harbors online, like the DMCA and CDA, will also still apply to the mobile market. So that's kind of a baseline understanding to have. Mobile technology does, however, present it presents amazing new opportunities, but also, again, some unique liabilities and challenges to think about. The online context in the mid-90s, when companies started creating websites, they found that they could now reach consumers that they had never had the ability to reach before. Mobile devices are doing that, but in spades. Most developing markets, a lot of the consumers there are not going to be able to own a PC, but they may have a tablet, they may have a smartphone. And the first statistic that's on this slide, I think, illustrates that in the fourth quarter of 2012 alone, consumers worldwide purchased 217 million smartphones. That's just smartphones. That's not the tablets and all of the other mobile devices that are out there. So this is expanding markets in ways that are unprecedented. And the point of the discussion today is to talk about sort of U.S. experience and U.S. law. That's what Dave and I are knowledgeable in. But we did want to take a moment to remind you to also be thinking about, as you're using these devices, where they're being used, and that there may be other laws in other countries that also apply. Certainly other countries, the European Union and Canada in particular, have much more stringent privacy policies, privacy regulations than the U.S. has. And so as you expand into using these new devices, it's important to think about all of the potential ramifications that may arise from that as well. Some of the other statistics here show some of the downside to not thinking through these issues, to not addressing them. The FTC has done a number of studies in the last couple of years, and the upshot of these studies is, well, one important lesson is really that the industries in general that are adopting mobile devices have either kind of forgotten that they are subject to the standard rules, or are just lagging behind implementing ways of complying with the advertising rules and some of the privacy rules that govern the relationship that you have with your customers. And there are practical ramifications to that too. The FTC study found that, one of the FTC studies found that 57%, one year it was 56%, 1 year it was 57% of app users had uninstalled or decided that they weren't going to buy an app because of privacy concerns. So that's over half of the people that you're potentially trying to reach. If you're not reaching them this way, you're missing out on those opportunities. And then there can also be the practical PR aspects, some of which were highlighted in the materials that Dave was presenting with regard to social media. I think one of the reasons that the industry has lagged behind, that all industries really have lagged behind in this area, is that, you know, it's a smaller screen, and we have a different relationship with our smartphones and tablets than we do with our computers. And so it's not as intuitive that you would be looking for a terms of service, perhaps, or a privacy policy. Where do you put it? How do you read it on this, you know, particularly a smartphone screen? How does a consumer know to get into it? And the FTC has acknowledged that there are some of these issues. They've been working with particularly the various platforms to try to come up with some practical solutions to these. They're encouraging various trade groups to get involved in this area. So to the extent any of you are involved with particularly different trade groups that are looking at it, I think now is a great time to have your voice heard. The FTC, in addition to doing all of these studies and releasing guidelines, is also enforcing the laws, though. And the past case from earlier this year, the settlement that occurred earlier this year, I think is a good reminder of what some of the downsides to the mobile opportunities can be. So Path is a relatively new social networking site, and they had a find your friends feature. And regardless of whether a user elected to find their friends or not, Path's software went in and collected, so it scrubbed or scraped the user's mobile address book. And they were sharing this information with, they were using it to market their own services, they were sharing it with other sites, with advertisers, and many of those uses were not properly reflected in the privacy policy. One of the big things that they were doing is they gathered personal information on more than 3,000 children under the age of 13. So 13 is the cutoff age of whether the Children's Online Privacy Protection Act, COPPA, applies or not. And because you have heightened regulation in that area, it's easier to enforce the rules, and it's also, we're dealing with kids, so it's something that the FTC and other regulatory bodies like to highlight that they are actively enforcing. And the important thing to note is there are a set of rules for sites and apps. Websites and apps are treated the same, but there are special rules if they're targeted to children under the age of 13 or any children. So if you have a special, if you're teaming up with Sesame Street to have a particular app that is, targeted to that market, maybe you've got a new set of hiking boots that's coming out, or poles that are specially designed for kids, or some other product that is targeted to that market, you really need to be paying close attention to complying with those rules. If you're a general interest site, so this is just your standard company site, you also need to recognize, are there elements on the site that are going to be particularly attractive to children? Are we collecting information? Are we asking for birth dates, for instance? How are we using that information? And you need to have mechanisms on the back end that can separate out the 13-year-old and under information, and then you need to be going and getting the parental consent. And there's a variety of ways of doing that, even if it is on a mobile device, but you do want to be aware of what it is, what the categories of information that you're collecting are, and then what the rules are that apply. And you can see here, so you look at it, the penalty in this case, the $800,000, was specifically for the COPA violation. And for 3,000 kids, maybe that doesn't seem like it's all that much money. I mean, it's still $800,000, but we're not talking about some of the settlements in this area are millions of dollars. But in addition to that, they have to have privacy assessments for the next 20 years. So they're under heightened scrutiny, and they need to be, paying extra attention to this. They also, this was a widely reported case, so they took a bit of a PR hit from it as well. So those are all things to think about as far as the downsides go. As I mentioned, the FTC, the state of California, they're really the two primary players in this area, but many other regulatory bodies and states are getting involved. There have been numerous guidelines that have been issued, studies that have been issued in the last couple of years, and I think the industry is slowly trying to catch up. Most apps that are available on iTunes and through Android still do not post their privacy policy or their terms of service. I would guess that even very well-known and well-established companies may not have gone back to rethink the terms of service and the privacy policy and how those relate to uses online. For instance, if you're taking mobile payments, how are you describing that? Are you, in your terms of service, are you putting prohibitions on what someone who is accepting, the person that actually has the device that's putting the information into that, are you describing how you're collecting that, what the prohibitions are on what they can do and can't do with the app? So those are things to go back and to think about. Think about who you're sharing the information to, or who you're sharing the information with. It's so easy to, and we have, if there's background noise, we have some window washers who are cleaning up our windows so that we can see the snow on the mountains even better. So excuse the background noise for a few minutes as we're finishing up here. But you do want to think about who you're sharing the information with. Are you going to be sending this out to Twitter? Are you sending it out to Facebook? Are you using it to populate various other third-party applications? And is all of that information reflected in the privacy policy? And then just making sure that it's accessible. So when someone goes into an app store and they purchase it, that you have links to your privacy policy in terms of service, and then also once they've downloaded it onto their phone, that you're making it available somewhere through there. And while you're doing that, I think as a practical matter, also make it in a form that is conducive to being read on a small screen. So thinking about the privacy, kind of the nutrition label concept, that might be something that is better suited to a mobile phone. And then the last area that has become a hot topic with mobile devices is the use of geolocation tracking. And from the regulator's perspective, they admonish over and over and over again, and so I think we're going to see more and more cases where people aren't doing this, that you really should only be collecting location information if you need it. And you need to make sure that if you are collecting it, you are describing what it is that you're collecting and who you are sharing that with, so that a consumer who has the app has some way of knowing that not only their purchase is being tracked, but where they were standing when they made the purchases is also being tracked. And with that, I think that we are going to sum up. We have a couple of more minutes if there are any other questions that have come in. There is sorry, I'm trying to see what's kind of a small screen. Either that or my eyes are getting worse with age. There was a question that came in with regard to how do you make sure that the terms of service on mobile apps are enforceable. And then a recourse or a question for Dave as to what can you do when you find out that a competitor is using one of your marks on Google AdWords. So quickly, with regard to making the terms of service enforceable, you have several options. Again, I think looking to make it a click-through agreement, certainly when it comes to provisions that you want to be able to enforce against customers, that's the best way of being able to do that. Removing any ability to unilaterally change the terms is also, those are the two things that courts have had the most trouble with in enforcing those agreements. And then, since we're almost out of, or we are basically out of time, Dave, do you want to give a quick summary of?
Yeah, just real quickly, so some of the recourses available for someone using your trademark as an AdWord, I would say if that's all they're doing, it's not a great idea to bring a lawsuit based just on that. It of course maybe depends on the law in the particular court where you're going to bring the action, because it does differ a little bit across the country, but for the most part, courts, you're unlikely to be successful there. But if that's, in my experience, if a competitor is doing that, they're probably doing other things as well that are actionable. And identify those things and bring it in, bring it as maybe that complaint as a whole, and throw the keyword advertising in as part of that. And in particular, I think we found that state unfair competition and unfair trade practice laws are particularly helpful and may rope these in where the federal trademark law cannot do that.
Okay, and I think we are now out of time. Thank you to everyone for joining us today. And if you have questions or would like to see any of the guidelines or other things that we mentioned, we'd be happy to provide you with links to those. Our contact information is on the last slide. Take care, everyone.